Disputes arising out of construction and infrastructure contracts were the subject of a law symposium at the Hyatt. The Law Association's president, Reginald Armour, promoted out-of-court dispute resolutions, while Queen's Counsel Stephen Walker noted there's wide room for an interpretation of contracts and the laws governing them. Atkins Chambers barristers and the Law Association of Trinidad and Tobago hosted the free symposium for lawyers, surveyors and members of the JCC earlier today. Here's more from Melissa Dasrath.
While the global trend of using a public-private partnership model allows for a cooperative arrangement between government and the private sector to fund large-scale infrastructural projects, disputes frequently arise as a result of delays, cost overruns, and shoddy work. A symposium on construction, infrastructural and contract law explored the avenues for mitigation and litigation. President of the Law Association, Reginald Armour, SC, said the Dispute Resolution Center of Trinidad and Tobago can lead to more amicable, mutually beneficial, and less expensive settlements.
Of course, of significant importance to Trinidad and Tobago within the broader context of domestic and international commercial arbitration has been oil and gas arbitration, and we certainly boast of developing strong residual expertise in this area.
Andrew Goddard, QC, specializes in the law of commercial obligations, professional negligence, and international arbitration, particularly in the areas of disputes relating to construction and engineering contracts. He said very often disputes arise out of PPPs because the service provider does not produce an optimal design and maintenance is carried out minimally. Stephen Walker, QC, focused on contractual interpretation and referred to the 2009 case of Connect Plus M25 versus Highways England Company that centered around a 30-year PPP contract, the termination of which would cost £90 million sterling, noting that when the literal rule is applied, it can result in an unfair clause.
Lord Denning called the construction of the contract a secret weapon, which judges used to stab freedom of contract in the back, even where the terms of your contract were clear, where the written words provoked no ambiguity. A judge might decide to change or depart from or not uphold the true meaning based on notions of fairness.
Not only can ambiguity in contracts leave room for the judge's interpretation, the legal principles can themselves be subject to interpretation. So as the English philosopher and jurist Jeremy Bentham put it, the power of the lawyer is in the uncertainty of the law. Melissa Dasrath, C News.